Code of Professionals, Canon 12. I'm going to discuss the Canons 12.03 and 12.04. Canon 12.03. A lawyer shall not, after obtaining extensions of time to file pleadings, memoranda, or briefs, let a period lapse without submitting to the same or offering an explanation for his failure to do so. The nature of a lawyer's work has a lot of pressure and there's a need for more time to finish the job. It often constrains a lawyer to ask the court for an extension of time to file a pleading, memorandum, or brief. But if a lawyer let the period given lapse and failed to make an explanation, it constitutes discourtesy to the court. In a Chacosa v. Court of Appeals, the petitioner's counsel, after having obtained 3 extensions of time for the filing of the reply, the counsel simply failed to file any reply nor to give the court the courtesy of an explanation or manifestation for his failure to do so. His conduct comes close to the delaying of the administration of justice and trifling with the court's processes, in that it does not reflect well on counsel's conduct as an officer of the court. The court censures the practice of counsels who secure repeated extensions of time to file their pleadings and thereafter simply let the period lapse without submitting the pleading or even an explanation or manifestation of their failure to do so. In this case, the court considered that Attorney Nera has no previous infractions since his admission to the Philippine Bar. Accordingly, the court hereby administers a reprimand on Attorney Rodrigo M. Nera with a warning that a repetition of the same or similar acts shall be dealt more severely. Asking for extensions of time must be in good faith, otherwise it is an obstruction of justice. The lawyer is subject to discipline. The same rule applies more forcefully to motion for continuance. Postponement is not a matter of right, but of sound judicial discretion. A motion for continuance is a grant of preparation time before or during a trial. Canon 12.04. A lawyer shall not unduly delay a case, impede the execution of a judgment, or misuse the court processes. It is also in the lawyer's oath that the law makes it the lawyer's duty to delay no man for money or malice. An example for this is a lawyer must discourage appellate review. If a lawyer is honestly convinced of the futility of an appeal in a civil suit, he should not hesitate to inform his client that most likely the verdict would not be altered. He should advise his client to accept the judgment of the trial court and thus accord respect to the just claim of the opposite party. He should temper his client's desire to seek appellate review of such decision. Unless he could sufficient cause for reversal, he would only succeed in planting false hopes in his client's mind, increase the burden on appellate tribunals, prolong litigation unnecessarily, and expose his client to useless expenses of suit. The procedural rules are precisely designed to accomplish the purpose of rendering justice to the parties to a lawsuit free from the law's delays. So a lawyer should use these rules for the purpose and not for its frustration. In Cal Perez v. Lentin, lawyers should not resort to, nor obey the resort of their clients to a series of actions and petitions for the purpose of thwarting the execution of a judgment that has long become final and executory. In Aguilar v. Manila Banking Corporation, once a judgment becomes final and executory, the prevailing party should not be denied the fruits of his victory by some subterfuge devised by the losing party. Unjustified delay in the enforcement of a judgment sets at naught the role of the courts in disposing justiciable controversies with finality. That's all for the Canons 12.03 and 12.04.